it's time to go to court for day 19 on May 20th, 2025 of the Karen Read Retrial. Yesterday's cross-examination was one of just the wildest things. The expert not only admitted to errors in the way that they approached their task, they admitted to errors in their May 8th report, which I thought was an update report. It seems like it was a pretty thorough extra report, said that they'd never ever done that before, and also purported on their company website, on LinkedIn, and on their company's CV to have a degree that is not on the CV they provided to the Commonwealth and the defense. Does it matter if they have the degree that they say they have online and not to the defense? The degree is not the point. It's the holding yourself out as if you have it elsewhere. That's the point. And then once you get there, everything is viewed with less generosity, because then you get to the issue with them asking the Commonwealth to do a bunch more work, to download a bunch more chips, or to re-download the chips, or to try to re-download the chips, to try to put the boards back into Karen Read's Lexus, because his fundamental error was he thought that they had not downloaded fully, because he misinterpreted the amount of storage that they had and how big those downloads should be. So when you're relying on a tech expert who is telling you that they don't understand the storage on the chips, I think it's hard to get beyond that for many. But he's back on cross today. We'll see if this will be the only witness today, because when you're Alessi, trying to finish this cross is hard because you never know what else you might unearth.
And these are all your slides, correct, sir?
Correct.
I will say the chat clocked this quite a lot yesterday, but here's the problem. It does start with January 29th, midnight, and then into the 30th. So he has the front date and the back date wrong. Yeah, no, that makes it worse, because he's showing these things from the 29th overnight. The actual date was the 28th overnight into the 29th, not the 29th overnight into the 30th.
Is your analysis down to, is your analysis on slide 36 accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
According to the Lexus.
Yes.
Did the Lexus have the date wrong?
In point of fact, Mr. Burgess, none
Of those are
of
correct.
the 5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware?
Sir, how did you not see the trap? That's for him
These
to figure out.
5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th.
What?
If I misspoke and said the 29th. Yes.
Okay.
No. What?
You understand my point?
Yes. Yes, I do.
Alessi's like, how do I even cross him when he doesn't realize how bad it is?
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct.
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion,
The jury's got to be sitting there going,
the applicable date, you're
the
saying,
29th.
as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct.
But
yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that. Yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Let's turn to a different topic. Lights up, if we could, and thank you for taking that down, Mr. Wolf.
God.
Now, in your May 8, 2025 report, you abandoned the call log analysis from your January 30th, 2025 report, correct?
No, I did not abandon it.
Did you rehome it?
You did depart from it, at least in some respects, correct?
I did not depart from it. I used another method.
Okay.
So the method you originally used, you no longer used. Is that not a departure? You changed methodologies, which is making me even more mad when the court said, this is not new information. It seems to be a complete fucking change in methodology. He went from looking at when calls were received on Karen Read's Lexus infotainment and calls received by John O'Keefe's phone, or calls made from Karen Read to John O'Keefe's phone. And he looked at the timestamp on those two things and said, okay, this is how we're seeing how in sync these times are. And then instead of syncing it between infotainment calls and calls on the other phone, he started syncing it between Waze data on the phone and techstream data. How is that not a completely different way to sync events? Unless you're going to say the methodology is more broad and you're linking the phone to the Lexus still, it's different. Linking app activity and the car driving is different than linking the two different call data.
In your May 8, 2025
Alessi, the
report,
microphone.
instead of applying the offsets
For the love of my ears.
from the call logs, which discrete points in time that are fairly easy to compare, as you stated just moments ago, you decided to use, in your words, quote, approximate time of the 3-point turn as your anchor between the two devices. Do I have that right?
Yes, you do.
Isn't what you did and we just discussed a classic example of confirmation bias, which is to be avoided in science?
No, it is not.
None of the information in that black box indicates that there was a collision on any day without more, correct?
Correct.
I'd like to
Which
now turn to...
I think cuts both ways, because the defense is going to argue that Karen Read collided with John O'Keefe's vehicle and it didn't register that either. What I have to wonder, he didn't review the data. What I have to wonder is, did the vehicle even register an event for when Karen Read was backing out of the driveway? Because we see it on video. Did the car register an event for that or not? Because that you can say, okay, this is on video and there wasn't even a trigger event for it. So it is 6 of one, half dozen of the other. We're at lunch. The Commonwealth's expert is still on the stand on redirect. There was a lot more cross to go. I think Alessi was incredibly productive on his cross-examination of this witness. And we learned again that when it came to the trigger information or the infotainment information or the techstream information, which are all synonymous, that this expert didn't have the raw data. He pulled the techstream information from Dr. Welcher's report. We still don't have a full explanation then of how they attributed the log events 1162.1 and 1162.2 to the different on-off of the car. We haven't heard how those have been attributed yet. Welcher might do that, but the reason this witness is testifying first is because this witness is the one who Welcher bases all the tech timing off of. So in redirect, as we thought he might, Brennan started with, you don't really need a degree to do the work that you do. You have certificates, and you've never said to anyone in court that you have a degree that you don't have. And this is what it says on your CV that you provided to the court, which said in progress, different than what the company website and stuff says. And Brennan asked, when did you write your LinkedIn? The guy's like, well, like 10 years ago. Did you write the website for your company? No. Did you have any input on that? No. Do you know how many people are at your company on the website? And he said, maybe 100 with 15 different offices for Aperture. Seems like a lot. But he said he didn't do any of the stuff that is on Aperture's website and that his LinkedIn was done over 10 years ago and he hadn't updated it. And in all of his time testifying, this has never come up. In the 10 years he's worked for Aperture, this has never come up. I would imagine most expert witnesses would beg to differ that their LinkedIn and the way they hold out their professional credentials doesn't come up, but he says it's never come up. How the jury will take that information depends. If they think that the defense is being hypercritical about it, they might be like, well, the one he gave the court is accurate, and he didn't tell us that he had that degree. And he says he doesn't need the degree for his opinions. So they might disregard it. They might not. I think I'm going to be more critical of it just because this is the field that I work in. And so I have a baseline that's different than an average juror. My baseline comes from being a lawyer and being in court quite a lot and watching more cases than that. It's wild to me. But jurors who might have never served on a jury before and don't really watch this might be like, I mean, okay, the one he submitted to the court's accurate, so I don't see it as a big deal. They might not. For me, if it was just the resume, I might be less critical. The resume is wild. But then you get to the issues with the bits and bytes, and then we get to the raw data not being evaluated. And there's a lot of questions. But on redirect, Brennan is bringing up, okay, well, why do you disagree with the way that the defense experts interpreting this data and where they're interpreting the data? And I think that testimony has been pretty clear. Whether the jury agrees with it or not is different. But I think the testimony with the redirect has come in clearly in a way that makes sense. He said, look, the defense expert is trying to align the clocks or correlate the clocks after 5:30 in the morning, and the information taken from the SUV's infotainment system when the car was off is just importing data from Karen Read's iPhone. So that variance is going to be 1 to 2 seconds from John O'Keefe's iPhone. Okay. But his report just has it on a chart. The chart that we've seen, and maybe it's elsewhere in his report, the chart that we've seen doesn't note that that's what the differential is. It's confusing information on its face. And yes, he's trying to explain it. It's not there. It's just a bunch of data and it's titled as infotainment system. And where we haven't gotten to in redirect that came up quite a lot in the rest of cross this morning was that this witness with all confidence said that the timeline that he presented in court was accurate to the second. And the timeline shows from January 29th in the evening through overnight midnight to January 30th. And that is not the correct timeline. And he said, no, this happened January 30th. January 30th, the SUV would have been sitting in Canton PD and John O'Keefe's phone wouldn't be doing anything. We haven't even addressed that yet. But on all of the slides that were shown yesterday, and if you go back and watch yesterday, you will see that they show the timeline on the bottom of those slides a little bit, and then the Commonwealth zooms in to the videos that are correlated with that slide. It's all in evidence that those videos that are being shown came from January 29th, not January 30th. But when you are asking a jury to trust an expert, when it comes down to seconds, when is it too many errors for a jury to rely on that? Not having the date right seems like we are not paying close attention to the details. Alessi did I think, a good job of pointing out how much the details matter when you are dealing with seconds. And again, why does this testimony matter? Well, for the Commonwealth, it's the basis of when they say Karen Read hit John O'Keefe with her car. And for the defense, it's the basis of where they say John O'Keefe's phone was still moving after the techstream data shows a backing up event. Therefore, at that time, John O'Keefe was not hit by a car because he was still interacting with his phone. And the injuries that he had would not allow him to be interacting with his phone. So if the injuries came from the vehicle, then how is he still on his phone? Because the time is different. So it is up to the Commonwealth to narrow in that timeline in a way that the jury finds reliable. The defense can say, how can you rely on this? And if they can't show you when the timeline is accurate, or if there are two reasonable explanations, could be this, then the jury's told they have to pick the reasonable explanation that points towards not guilty, because the reasonableness goes to the heart of beyond a reasonable doubt. If there are no other explanations than this happened the way the Commonwealth said, then reasonable doubt loop has been closed. But if there are multiple reasonable explanations, then that reasonable doubt loop hasn't been closed. And the defense has been much more, I think, laser focused this trial on reasonable doubt versus the last trial. And the Commonwealth is trying to narrow in this case and the contradictions. There's a lot the jury does not know. There's a lot of witnesses that were called first trial that aren't called yet. And though we know it, if we've watched the trial before, the jury doesn't know it. So the jury, I'm sure, is sitting there still trying to piece together a timeline because they now have some vague idea that this 1162 is a backup event that may have been when this happened. And the jury, I'm sure, is sitting there still trying to piece it together because the puzzle's not clear to them yet. But on day 19 of trial, shouldn't the puzzle be more clear? So when are we going to get to Welcher's testimony? Because we've heard a lot about it today. And the Commonwealth seemed to indicate Welcher's testimony might be next week. So we got a long way to go. So who's the witness they call after this? Because it sounds like it's not going to be Welcher. Is it going to be the medical experts? It might be. The rest of today is going to be very interesting. But remember, the way we see things with the information that we have and the way the jury may see things can differ. And there's a long way left to go in this trial. But this witness has said, I never said on the stand I had a degree. I never represented that in any court. And this is how I parse the data. I find the explanation about the data more clear than I did last trial, but that's going to come down to how reliable this witness is viewed. It's going to be interesting to see how the defense expert that's going to talk about the same issue, DeSorga, I think, because it's been pronounced like 17 different ways in court, how those two things go together. Because the tech timeline is between this witness that's testifying today and the defense witness DeSorga. The accident reconstruction is going to be between Welcher from Aperture and Wolf and Wrenchler from ARCA. I can't believe we are 19 days in and we've got a long way to go. But also the Commonwealth's getting towards the end of their case. And it seems more and more like they are not going to call any more civilian witnesses, which means they might not call the Aruba witnesses either. They might not call anyone else that was at 34 Fairview. They might not call, and it seems more and more likely that they won't call Proctor or Tully or Higgins or anyone that lives at 34 Fairview. And I think that leaves a huge door open for the defense to argue, what hasn't the Commonwealth shown you? And why? Because they've heard these names over and over and over again. And is that enough for them to argue doubt to the jury? What is the Commonwealth not telling you? And why?
So we approach from the north, we actually missed the turn. And John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own was Cedar Crest, and then come from the north onto Fairview.
Like the next play, clip 25.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage truck. And then you hear the car go off, and then you hear the slight ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door, you hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30. on the early morning of January 29th.
At the end of day 19, the court stopped, I thought, kind of abruptly, maybe 15 plus minutes early, as we had just gotten into a scientific witness. We had just gotten into the trace witness from the lab who did the mechanical match on the glass. And we had gone through background training and experience, and then the court called everyone to sidebar and excused the jury about 15 minutes early for the day and told the witness they'd need to come back tomorrow, and told the witness they'd need to come back just a little later. I don't know if court is starting later tomorrow or if there are things the lawyers need to address with the court before court starts. I guess we'll see tomorrow. And if I find out more, I'll let you know in the Law Nerd app. But at the end of the day, we did in fact finish with witness Burgess. Did the redirect help? Well, it's really going to depend on how you see this witness. If you see this witness as someone who you kind of lost faith in the carefulness of their analysis, then no, the redirect's not going to help at all. If you're looking at this witness going, okay, I mean, I don't think the CV thing's that big of a deal, which jurors might, then did the redirect help focus on the data? Yes. Because there were a lot of parts of Alessi's cross-examination that did not focus on the data the witness was bringing forward. There were definitely parts that did, but there was a lot of it that focused on whether the witness was credible. And if the jury finds the witness credible, there are points of the data that are consistent with what the defense says too, and points that aren't, because it all comes down to the window of time that Karen Read's car has a backup event and John O'Keefe's phone button clicks closed and then does not open again. So it really depends on how this witness is seen. But the fact remains that the time when John O'Keefe's phone click button closes is the last time from all the experts we've seen that there is user interaction with the phone. Other data is written onto the phone after that, but that user interaction data time seems pretty firm to me. Maybe it will shift as we get into other witnesses, but at this point, that time of 12:32:09 when the device locked seems like a pretty firm time. So the question remains, when was Karen Read's car backing up? And was it covering that time? Or was that backing event done before that period in time? And when the medical experts come in, I think that this will become much more apparent as to why it's necessary. And we heard some of those questions in cross-examination with the defense asking the coroner, is that the type of injury you would expect someone not to have volitional movement or the ability to manipulate a phone or et cetera? So we know the direction that's going in from the defense. And then at the end of that testimony, the Commonwealth played 3 clips of Karen Read in her own words. One of the clips talked about the 12:41 a.m. voicemail that we talked about where there's beeping. And Karen Read explains everything that happens on that voicemail. The beeping at first in the voicemail is the beeping of the car going into the garage with like the walls. And so it's beeping from the sensors on the side. And then you hear the slower beeping, she said, when you open the door, the open door sound. And then you can hear, she explains, her going into the kitchen with her high heels and walking into the kitchen on that voicemail. Do I think that that explains everything that's happening on that voicemail? It does. It's really consistent. So then if the defense is trying to push the time forward to show that she connects to the Wi-Fi sooner, what do we do with that 12:41 period of time? I imagine you will hear the defense argue that she connected to the Wi-Fi and was waiting for the garage door to open and was in the driveway before she pulled all the way in. And I imagine you'll hear the Commonwealth say the Wi-Fi could have connected down the street and she was still driving back to One Meadows at John O'Keefe's house. And that the time it takes to get from John O'Keefe's house to 34 Fairview isn't enough time with the way that the Commonwealth has looked at that time. That's where we're getting to on the timeline. And then we have another clip of Karen Read talking about the fact that we, and I assume we to mean her and her legal team, we think John died around 12:25, 12:30. While the defense might quibble with that time in their presentation of the evidence, I think listening to Karen Read say this is the timeline will be impactful on the jury. And we will see how that continues to be illuminated as we get into all the expert witnesses. And the defense will probably argue, well, with stress and hindsight and this and this and this and that, 12:20 to 12:30 or 12:25 to 12:30 doesn't make sense with what the digital evidence says. And people get things wrong. And I wonder if the defense will point out the things the Commonwealth witnesses have gotten wrong. Because when we got to the recross of the tech expert from Aperture, the defense was like, hey, so this filing in federal court in Texas from 2023 shows that on your CV, you said that you had a BGS Bachelor of General Science, and the date there was 2024. Did you submit to a court a resume that said that you were anticipating your degree in 2024? And it was, well, my company submitted it and somebody else handles that. But yes, I anticipated that I would receive the degree in 2024, and nobody asked. And I suppose it's because the lawyers don't know the answer, and you don't ask questions you don't know the answer to. If this witness was enrolled in 2023, how many credits they have? Why did they think they were going to get their degree in 2018, and 2022, and 2024? And why does it keep shifting? And why does it now say in progress? And when it was asked on redirect, redirect, it was asked, so you anticipated finishing your degree? And the witness said, yes, I hope to finish my degree, but work and life and family get in the way. But then why is the degree still listed in multiple places? And is it a typo on an old LinkedIn account? Or is it 2016 to 2018 and then 2022 and then 2024 and then in progress? So it's been updated. Is it intentionally misleading? Or is it just human error because he still intends to complete the degree? It's going to be up to the jury. But the more the dates keep changing, the more it looks like he's well aware that the degree is not complete and that it's on the resume, in the education section of the resume. So why put it there if it's not done? The jury's going to get to decide the credibility of witnesses. But I've never seen an expert get called out on a resume like that. I've seen people quibble with if this article was peer reviewed, if that article wasn't peer reviewed, are you board certified or not? I've seen those quibblings over the education of experts. One expects that type of quibbling with the education of experts. But I have never seen, yeah, I expect to get my degree next year for the past 17 years. That I've never seen. But the way the expert explained the timing made sense to me. How much weight the jury will put into it, it's on them. They get to decide. But the way he explained the timing made sense. I'm curious to see how the defense expert explains the timing variances. And at some point, if the defense just says, you know what, we're not worried about the timing variances because none of the other information shows that John O'Keefe was hit by a car, because that is what they said in their opening. Sure, you can say it's this time, you can say it's this time. None of it changes the fact that the Commonwealth hasn't shown you that John O'Keefe has been hit by a car. And the witness that the Commonwealth is expecting to do that is also from Aperture. And it seems that we'll maybe see that witness next week. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.